Thank you very much, Patty, for the introduction. And thank you all for being here for this session. As Patty mentioned, I am a research advisor for the Community Engagement in the State Courts Initiative, and I'm also an assistant professor at Michigan State University in the School of Criminal Justice. My research really focuses on public trust in governmental institutions. My co-presenters and I would like to spend the next hour or so talking with you about engagement. As you all know, the last few years have brought the relationship between criminal justice institutions and the public they serve into sharp focus. And as a result of this, a lot of people have been looking for strategies for ways to protect their relationship or to improve that relationship. And engagement's become a really important piece of that puzzle. So our session's intended to do two things. The first is to give you an overview of a few different types of engagements on a few different levels. And the second is to create a forum for discussion so that you'll not only have a chance to ask us questions, but we can actually get a chance to hear a little bit about what you all are doing and what you're planning to do. So the Community Engagement in the State Courts Initiative is a State Justice Institute-funded partnership that includes the National Consortium for Racial and Ethnic Fairness in the Courts, the Conference of Chief Justices, the National Center for State Courts. And it seeks to build partnerships, and it seeks to build and disseminate tools to help courts engage with their communities. And at the helm of the initiative is an advisory board that's chaired by Chief Judge Eric Washington of the D.C. Court of Appeals, but also includes members of a number of governmental, not-for-profit, and for-profit organizations as well, that include the National Council of Churches, the National Association for the Advancement of Colored People, the American Federation of Teachers. And as Patty had mentioned, the board is staffed by Tina Vigenis of the National Center for State Courts. The center's president also serves as an ex officio member, as does Jonathan Mattiello of the State Justice Institute. Jonathan Smith of the Washington Lawyers for Civil Rights and Urban Fairness serves as the reporter, and myself and Dr. Alan Tompkins of the National Science Foundation serve as research advisors. So the board's mission is to develop effective tools and resources that assist state court leaders in engaging these marginalized and disenfranchised groups with two very explicit goals in mind. And the first is to ensure equal access to justice for all. And the second is to ensure to increase the trust and confidence that these communities have in the efforts of their state courts to protect their rights and to resolve disputes fairly. So to that end, the board's embarked on a multi-phasic effort to lay the needed groundwork. Now, as with any effective engagement, the board's activity started with an information gathering or listening tour phase that I'll talk about in more detail in just a moment. Now, this phase allowed the board to capitalize on its own expertise, but to move beyond its own assumptions and to engage the public to really understand where the critical issues are in the relationship between the public and the courts. From there, the board's been working to distill the information that was collected into a few key themes that are then going to be used as the focus of pilot projects, in which the board will engage with one or more courts to try and create interventions and then evaluate those interventions around these issues. So as I mentioned, the centerpiece of that first phase was a listening tour, whereby the board was trying to engage the public on a national level to really understand the major issues in that relationship. And fortuitously, Tavis Smiley and his team over at PBS actually provided the perfect stage to do this. So using Tavis's show as a platform, the board convened a number of town hall-like events in California, Arkansas, and Ohio. Usually the panelists, or all of the panelists on these, were jurists, and so these would include the Chief Justice or the former Chief Judge of each of the states. They also included some district court judges, municipal court judges, and appellate court judges. The invitees to the tapings included representatives from a number of community and civic organizations, and to some extent the general public. And I say to some extent because it did require an invitation, but the organizers did a really great job to make sure that there was a wide variety of people who were invited to these events. So to give you a better feeling, I knew I was going to do that. To give you a better feeling for the events themselves, I want to show you a brief video that was edited down by the National Center for State Courts from the full tapes of those courting justice events. And if anyone's interested, those tapes themselves are available on Tavis Smiley's website at PBS, but they're also linked to from the National Center's website.
The erosion of trust in our judicial system has prompted many of this country's most influential judges to call for a new openness with the communities they serve, and our audience are stakeholders from those communities. But tell me why judges are willing to take off the robes, come off the bench, and engage in a conversation with the people you serve.
Well, I think the short answer is that judges' stock in trade is the public's trust and confidence that we will protect rights and liberties and that will resolve disputes fairly. And yet, what we were seeing around the country in light of what had happened in Ferguson and the law enforcement involvement in Baltimore and around the country was an erosion of that trust and confidence beyond what it had been before. And we understood that people, the community at large, was very interested and very confused about the role courts play in the justice system generally, and especially with respect to law enforcement. But the issue for us was one of trust and confidence. Without engaging, without trying to figure out why they believed that we were somewhat complicit in this justice system that they viewed as unfair, we could never address the problems from within. And certainly we have an obligation to self-examine to determine whether we can do better, so that communities who come before us wanting justice will feel as though we've done our jobs.
So I wonder, Judge Rivera, whether or not it is your opinion that the damage that's already been done, particularly in communities of color, is irreparable.
Oh, I would never say it's irreparable, but I think it's definitely a wake-up call.
Justice O'Connor, whether or not people of color and poor people tend to be disproportionately treated in a punitive and pejorative way by these LFOs, these legal financial obligations?
I think there's no question that that's what's occurring, and that's why we have this discussion, why we have this movement, why we have the courts and other members of society addressing that at this point. It became painfully obvious after Ferguson of what the circumstances were in Ferguson, where the courts were literally an ATM for the municipalities at the direction of the governance of the municipality, instructing police in concert with the courts to raise revenue, because we need. And how are we going to do that? We're going to issue more violation, citations, and that is going to result in more fines and more dollars in the city coffers. There's no justification for that whatsoever.
Judge McGee, while they're studying it, and I'm glad they are, people are still being maltreated by this process as it is currently constructed every day. And it may be the case that the judges have finally figured out that we ought to study this and figure out a different way to do it. But people of color have been complaining about this for years.
That's right.
Poor people have been complaining about this for years, about how they're being, again, handcuffed, as it were, by this process. Why is it that it's taken so long for this issue to rise to the top?
Well, part of it is I think you need people on the bench and people in power who are willing to listen, right? So as you talk about diversity, diversifying our bench so that there are people on the bench who share common life experience with the people that they have appearing in front of them, really taking time to be introspective, increasing training for judges, because the reality is if you're sitting on the bench, you may think $100 fine is no big deal because you're not that $7 an hour worker where $100 fine is extraordinary for them. And so then they can't pay the fine. They get a warrant issued for them. They lose their job. I mean, it becomes cyclical. And so part of what's happened is you've seen a confluence with the leadership of the Chief Justice here in Ohio, judges on the bench like the two sitting here, who are really working with their fellow judges and making sure that we have appropriate training and that we understand that our orders have impact on real people. But it's taken a long time because we haven't had people that look like the communities sitting in seats of power.
It's common knowledge that up to 95% of people charged with the crime take a plea deal, and the criminal justice system is not designed to give people a trial. If 25% of those charged with the crime went to trial, the system would overload and crash. How can we correct this broken system?
Sounds like Susan went to the library and got herself ready for this question. Good Lord. All right, thank you, Susan. Who wants to?
As a trial judge, Susan, thank you so very much for that question. Firstly, let me say that public defenders all over our country are overworked and probably underpaid, but I can't change that. as a judge, what I can do is when defendants are standing in front of me, I'm very cognizant of the plea. I'm very cognizant of the plea deal. In my state, defendants are permitted to plead non-pursuant to the state's recommendation. So therefore, it gives the judge some discretion with respect to sentencing. And sentencing in my state is what we call indeterminate. So there are ranges of punishment. And so judges do have and play a big role in terms of plea proceedings inside of the state of Missouri.
I think the question is whether or not you think that judges have too little or too much discretion.
I believe that judges have sufficient discretion. And I believe, though, it has to be an educated discretion. And judges' discretion is always informed by A, their personal background, their experience, their values, their principles, but most importantly, by the statutes that the legislature passes and the governor signs that says what a judge can and cannot do. And in addition to what Justice Rivera was saying about the strides we make in trying to raise the consciousness and educate our judges, I want to be clear that we heavily teach the disciplines of law as well. That is first and foremost our commitment, that judges get it right.
Yeah. Bias. Is the court biased?
I don't believe the court as an institution is biased.
Mm-hmm.
I think what we have a need for...
Did you hear that laughter around the country just now? Respectful.
What we have a need for is a better understanding of what we call our implicit biases.
Okay.
No one sitting on the bench is going to admit, oh, I have racial bias, I have gender bias, I'm biased against immigrants. They're never going to admit that, and they don't believe it. Genuinely, they don't believe they are biased.
How can we as taxpayers, teachers, parents, etc., use our power to battle school policies which mirror the criminal justice system in which there is crime and punishment without the concept of rehabilitation?
We need to revamp our disciplinary problems for one. And really what we need to do is we need to have real social workers, behavior therapists in the schools. So often, and I don't want to dump on the schools, we have not really equipped our schools with the tools that they need to meet the population that they presently have. And so we have to rethink that. And really, I would get less business if in juvenile division court if we picked up these problems earlier in the schools. But that means we just don't willy-nilly suspend a student from school. If a child is doing something that's so disruptive, we need to take a time out. Have a staffing, call the parents or custodians in, get a social worker in there. There may be something going on at home. There may be any number of things, but we don't take the time and to figure out why is little Johnny acting the way he's acting.
And so the first question tonight for these jurors will come from Mary Jane Trapp. Mary Jane, where are you?
You've recognized the problem of the disparate impact of bail decisions on the poor and people of color. How do you achieve a statewide or a uniform, fair system of bail reform when you have a state like Ohio that has so many different municipal courts, county courts, common police courts that are in rural areas, that are in urban areas, and suburban areas?
Can these reforms be universal?
So whether you're urban, rural, or suburban, the same law applies. And it is, as my friend Yvette McGee-Brown said, a matter of education for the judiciary. This is truly a paradigm shift in many respects with how business is done in our courts. And that requires education and training and consistency. And those are the hallmarks of a successful change.
Fred Barrett, your question, sir.
Hello. I have a simple question. Many people have different views of justice. What are your views of justice? What's your definition of it?
Wow. I don't know that I have ever heard that question, powerful question. I don't know that I've ever heard that question asked of a judge, of a jurist. What is your definition of justice? But, Judge Adrian?
For me, When I'm talking about justice, I'm talking about what I do from the bench, what my actions are, and it's all about fundamental fairness. It's about fundamental fairness, both real and perceived. I had the occasion to chair the Ohio Commission on Racial Fairness. We went all across the state listening to people about what they thought about the way the system functioned and whether it was fair. And one of the things that came out very clearly was that there were two different perceptions of justice in Ohio. One that was held primarily by the majority community, and another that was held by, the minority communities. And the majority community, by and large, felt that the system was fundamentally fair. The minority community, by and large, felt that there were significant problems with fairness. So for me, it's for people to see what's going on and be able to see what's going on transparently in the justice system and conclude, after they've seen it, that regardless of what the end result is, that it was fundamentally fair.
Let me thank now, though, everyone who made this town hall possible, the distinguished panelists as well as our audience. Please thank our panelists, please, please, please. As well as the audience and our partners in this town hall, WVIZ, PBS Idea Stream, as well as the National Center for State Courts. And finally, we welcome your input on how courts can regain your trust. So please join the conversation on Twitter and online. Once again, go to pbs.org to hear more, to see more of this conversation. Thank you for watching this program tonight live from Cleveland. Until next time, keep the faith.
For more
So starting with those videos as our data initially, we've been working through those videos to distill it down to a few key themes that I want to suggest to you now. Across those meetings, issues of fairness were obviously very salient, but that happened in a few different ways. One of the ones that probably stood out in that video just now was this idea of plea bargaining, but there were also conversations about implicit bias and the effect that that has on judicial decision-making, and conversations as well about the lack of diversity on both the bench and the jury pool that's at least thought to create the perception that the courts aren't able to understand the experiences that their public is going through. There's also a recurrent discussion of the prosecution of criminal justice professionals that was aimed mostly at the police, but there was a conversation in the California taping about the judge in the Brock Turner case specifically. Another major theme that came up was what Tavis Smiley poignantly called predatory government. And so these are situations where governmental institutions, the courts, are trying to extract revenue via legal financial obligations. This was actually enough of a theme in the first two that it was intentionally set up to be the theme of that Ohio taping. Bail issues were also discussed, but those were mostly focused at bail bondsmen specifically, which are out of the control of the courts, but there was a conversation about how their ability to engage in predatory practices really does rely on court policy. The third major theme centered on engagement opportunities, and it was typically brought up by participants as a needed avenue for being able to have their concerns heard. Engagement task forces were typically pushed as the big response to this, but all of these conversations, or almost all of these conversations, ended up in a discussion about the need for these communities to actually make the effort to engage with the courts. I actually think it was Tavis Smiley who pointed out that both voting and jury service are well entrenched in law and policy as ways to impact the courts, but both of those tend to be underutilized by the public. And the last theme was addressed primarily within these questions of engagement, and it really highlighted the reasons why engagement is hard. The indifference of minority communities was pointed to in a few of these discussions, but one of the big issues was a lack of data to really allow these conversations to go beyond what people think is happening and to have a more objective conversation about the problems and then the likely solutions to those problems. Interestingly, but probably unsurprisingly, there was also a major theme of the complexity of the courts, and in particular the need to realize that a lot of the policies and decisions that appear to come from the courts are actually constrained by legislatures or the results of decisions of other groups like the police or parole boards. So as I mentioned previously, the goal of identifying these themes is to try and end up with a prioritized list of them. And so while we have you as a somewhat captive audience, I want to ask you all whether anything here really stands out to you as being something that is particularly ripe for pilot projects, or something that you think is overemphasized here and something that really doesn't need that extra attention. I think we have a microphone running around if anyone wanted to jump in on that one.
Well, I think the engagement task forces is definitely ripe for a pilot project.
Sure. In terms of knowing how effective they are or how they work, or?
Well, in terms of exploring those as avenues for engaging the community, I think, that's something that it's an avenue that has been overlooked, I think, and looking at ways to bring members of the community in to engage with the judicial system and gather input and look at where we can start to make inroads.
Thank you. Well, let me ask the more direct question. Looking at these four main themes, so that fairness, predatory government, engagement opportunities, and the barriers to opportunities. By show of hands, who would argue that the most important here is that those questions of fairness? Okay. How about predatory government? Engagement? And then the barriers to engagement. Okay. Okay. Well, this is exactly what the board's next step is to keep soliciting this type of feedback from individuals. That was the wrong button, wasn't it? There we go. To keep soliciting this type of feedback and to get that from an online survey of elites. And what I mean by elites is individuals that are in a position to represent their communities, either because they've been elected or appointed to do that, or because these individuals are members of community or civic organizations that are trying to address these issues. And then using that, there's a few examples of the types of groups that will be involved with that, but that's going to include the attendees and the members of the National Consortium. This is also going to include all of the advisory board. It'll include all of the attendees of the courting justice events and other people as well. From that list of prioritized areas, the idea from there is to begin a series of pilot projects. So the board will reach out to courts in various jurisdictions with one of those themes in mind. And the idea will be to have that jurisdiction start with a public engagement. And so this will be an effort where they'll bring the community in to try and understand how best to address that issue. And from that engagement, an intervention will be designed, and then it'll also be evaluated with the help of the board. So at this point, I'll go ahead and turn it over to my co-presenters. Amy, got you up next.
So if I use this microphone, I don't have to turn on my pocket, right? Yeah. So I laughed when Patty introduced me as 8 days as state court administrator, which is true. But the things I'm going to talk to you about, I actually have been working on for a little bit. So it's not like I don't know anything about it. But the slides that I have are jam-packed with information about some of our reform efforts, and I'm grateful to our staff who helped me put them together, but I'm not going to really talk from the slides because while they have a lot of good information about our reform efforts, what I thought might be more helpful to you is to talk to you about some of the challenges we faced along the way. I'll tell you some of the good things I think we did, and I'm also going to share with you, quite honestly, some of the mistakes that I think we made. So all of our reform efforts have really relied on community engagement. And it has not been a linear process by any stretch of the imagination. In fact, several times we'd have to backtrack before we could move forward. But there have been a lot of lessons. So when our current Chief Justice Strine, took office in 2014, our Access to Justice Commission was just getting started. And for those of you who have them, you know that they're really focused on civil issues. But he was really interested in criminal justice issues. And so he wanted to have one of the committees focus on criminal justice. And so he created the Committee on Fairness in the Criminal Justice System. And that was driven by a couple of statistics in Delaware, and I'll point them out really quickly. One, depending upon what source you're looking at, our little state of Delaware with 900,000 people is as high as number 3 in the country in terms of our rate of our population that's incarcerated. Second statistic driving the need for our criminal justice reform is that our general population in Delaware is approximately 60-20 white-black. In our incarcerated population, that's reversed, and it's even worse in our juvenile populations. So those were the issues that the Chief Justice wanted us to start focusing on: fairness in the criminal justice system. So that's a really amorphous topic, right? I mean, talk about wondering what is fairness and how you define that. The first thing we did was we created a committee that was made up of community personnel, so community leaders, business, academics, and all of the usual suspects from our criminal justice system were also involved: Department of Corrections, PD, AG, courts. But we brought those people together because we really wanted an outside perspective on the system. So the Chief Justice asked us to frame our issues and asked us to concentrate on 4 questions as we were trying to frame up what is this group that's going to talk about fairness going to do. And so he asked us to think about the following questions, and they've really guided our progress throughout. 1 is, what should we be talking about? 2, why aren't we talking about it, or what's difficult? What is the challenge? 3, how do we make progress, and where do we go from here? So the question about what we wanted to talk about was really first and foremost, and we had no idea. So we reached out to experts from University of Pennsylvania, University of Delaware. Brian Stevenson, who thankfully is a Delaware native, and his Equal Justice Institute helped us, came to Delaware and started to look at our data. The first thing we figured, okay, easy, we'll try to target some reforms. But the first thing that we realized is we didn't really have any data. There was no common benchmark for us to start to look at what we needed to address. So back to the drawing board, we engaged with the University of Pennsylvania and did our first ever disparity study, looking at caseload studies from 2012 to 2014. And I'm pretty sure I should be on my next slide. And what that helped us to do was to direct us to the topics that we should be focused on, and that included bail, sentencing, policing, alternatives to incarceration, and root causes, which is looking at the underlying factors to the fairness, so things like poverty, education, and a panoply of other things. So we looked at those issues. We asked our experts to go out to the states and look at reforms that have been done in all of your states, take them back to Delaware, and start to have a conversation about what we might want to look at further. So we started by thinking about, well, how do we want to have those conversations? How are we going to engage the public? So the first thing we did was we had some informational hearings where the experts would present on their findings, and then we invited the public to come, and of course we thought, oh, we'll put it on a website and we'll maybe put it in the newspaper. Well, that's not necessarily going to engage the public that we want to be coming to these hearings. So we had to go back to the drawing board, engage our faith-based organizations and our community leaders, and reach out with flyers and go to church meetings and have conversations about why it was important that they engage and come and have that conversation with us. So one of the lessons learned, so communication, we know, is about giving information, but that doesn't stop there. The second piece to any kind of effective communication, we soon figured out, is that you need to do some listening. So in addition to the informational hearings, we held public hearings up and down the state, after hours, in churches and schools and the like, to have the public come and comment on the information that the experts had given us. And we heard a lot. We got a lot of comments on our website. Our staff had to cull through that and sort of issue spots so we could bring that back to the Fairness Committee. And from there, we started to have some ideas for reform in these areas. But it was very clear that even though we had this great information from these amazing experts and the public coming in, and they were pretty well attended, it isn't necessarily true that the people in the room talking about the same things were actually focused on the same issue. So I love the idea of the fact that what is the perception of justice? We can have multiple ideas of that. So it soon became clear that we may be talking about this from different perspectives and never coming to a solution because we really weren't communicating with one another. So one of the things we needed to do was think about, well, why is that? So the idea, we went back to our experts and they led us to start to have a conversation about what baggage are we bringing to these conversations, what perceptions are we bringing that is not permitting us to connect with our communication so we can come up with some helpful reforms. So we started to focus on implicit bias, which I'm already onto my third slide. Implicit bias training. So we engaged with Rachel Godsell, Professor Godsell from Seton Hall, came in and did a training, 10,000-foot level introductory training to all of our criminal justice partners, from law enforcement, the courts, from the Department of Corrections, and it was an introduction to the concept. And as you might imagine, folks with different perspectives were all coming to the table with different opinions about whether they had implicit bias, whether they were interested in talking about it at all. Rachel did a fantastic job of really giving a nice introductory review of what that is, and we decided to do it together with all of these folks at the table because in that way it was our community that was coming together. It wasn't just one organization that was becoming vulnerable and having to talk about implicit bias and, oh, maybe that's my fault, or I'm the cog, I'm the kink in the wheel. We all decided to engage in this together so that we could all address this as a system. So after that introductory discussion about implicit bias, we're now going to be meeting in July to have a more in-depth conversation where we're going to be talking about bringing in that training to all levels of these agencies and organizations and embedding it through video modules, train-the-trainer sessions. My sincere hope is that we then move on to a phase 3, because while we all know that there's implicit bias and that impacts conversations and our ability to hear one another, one thing we haven't figured out, as I understand it, is what to do about it. So my hope is that the system partners will be interested in looking at a phase 3, which is to look at the different discretionary decision-making pieces in the different organizations and try to adopt some procedural changes that would actually impact implicit bias. Another thing that we're going to be doing is releasing a survey. The Fairness Committee is working with our Council of Police Chiefs, where we're going to be sending out a survey to the community at large and asking about their perceptions of police, the policing departments, and probation and parole. That same survey is going to be administered to the police and to the probation and parole, and from that we hope to gain some more understanding about what the disconnect is and why we're struggling in having the conversation. I'm going to show a clip at the very end because I think and get back to the point about the conversation, because it's so critical. But I wanted to touch on a couple of our reforms that we are working on using community engagement to drive these. And one is pretrial bail reform. We were here in Alexandria with our sister states talking about that not long ago. We are engaging, we are a smart pretrial site, and so we were working with them, with our Fairness Committee, to come up with some modifications to our pretrial system. And we've done focus groups and community engagement to talk about what we should be changing and what those issues are, and we'll continue to have those conversations. Another thing that we targeted was the sentencing. You recall I mentioned the study that told us, I actually don't think I did tell you. The study led us to look at pretrial sentencing and arrest issues, which is why we're targeting these reforms. One of the reforms we're looking at is a comprehensive review of our criminal code, because transparency is so important. And our Fairness Committee realized that the one document that dictates to us, it's our social contract about what we should and shouldn't do in our community, ought to be a document that the average citizen can pick up and understand. The transparency with which that is applied is so critically important. And we had not done a comprehensive review of our criminal code since 1973, when it was first adopted. And like many states, when you're adding and you're adding and you're adding, and you're never taking the time to go back and see what you've done and what you've now created, lo and behold, many moons later, we have tentacles and a document that looks like nothing what it resembled to begin with. So we're looking at trying to simplify that document, reducing, taking out some of the ways that it conflicts with different provisions. And so we're working with the community, and we've gone out to the community to educate and have conversations about that. So all of those, the ways that we are trying to engage the community and have conversations. Now, it hasn't always been easy. And one of the critical things we realized is that It is hard to have a conversation about these things. If it wasn't, we had made these changes many moons ago. It's difficult. And what are the barriers to that? Sometimes it's a common language, very often perception, and how can we, people of good faith, come together and engage our community and have these most critical conversations. One of the things that was clear to us in all of our different reforms that we've been trying to enact is that it can't just be one conversation, and it isn't just one reform. It's 100 conversations, it's 1,000 conversations, it's 100 reforms. And we need to be patient because it takes time. And so I wanted to play a clip because I think it highlights some of the work that we've been doing.
62% of the African American males in the city of Wilmington are either incarcerated.
Oh, I didn't. Okay, good. So this is a conversation about the conversation. The Chief Justice, very cognizant of the difficulties and the barriers that we kept running into every time we tried to have an engagement with the public or have a conversation about the reforms and the different perceptions that were being brought to the table that were really preventing us at making any strides. Led him to join up with some of the folks from our Fairness Committee. You'll see there retired Colonel Setting, who's our Newcastle County Police Chief. You will see Charles Madden, who is the Executive Director of the Achievement Center, which focused on reentry issues. You will see John, can't remember his last name, but he is the editor for our News Journal paper. B.B. Coker, who's our community activist, and our Chief Justice on the right. They got together with the Historical Society and invited the community again to come in and invited them to have a conversation about having the conversation and some of the difficulty that I've been describing that we keep bumping into when we try to do just that, engage the public. Charles does a nice job at outlining some of the challenges we face. You'll hear the Chief Justice in this clip talk about, and he's responding to a question about his view on educational challenges. And finally, and I think most poignantly, you'll hear a comment by one of the community members that addressed us that really puts the challenges out there for us to think about. So.
62% of the African American males in the city of Wilmington are either incarcerated or on probation or parole. Mm-hmm. So 6 out of 10 men in the communities right outside this door are not functioning in mainstream society. And so, you know, when I think about, again, the contribution to this conversation and how you would have this conversation, one of the things that I sort of grapple with is this notion of suspending judgment, right? And this idea of patience, right? So when you start having conversations about race, and Chief Justice Strine, I was going to call him Leo, and I've had this conversation quite a bit. And the idea is when you start talking about race, it gets to be very polarizing. So people take a position, they stick to their position, and they're not interested in anything else that's outside of their position. So what I always say is you have to suspend judgment for a minute. You have to suspend judgment and recognize that those of the privileged, white, have to be patient. But I hope that when people walk out of the room today, that they become aware of the need to have the conversation, and the difficulties there are in having a conversation. One of the things we like to do is rush to a solution, and I'm the king again of impatience and want to get to a solution. So again, I'll give you my perspective from, again, personal and my professional experiences here as of late, is one of the things I keep saying is we have to suspend judgment, right? And so one of the things that I have come to learn is that we have sort of this belief that our way is the only way and it is the right way. And the challenge with that is, as diverse as we are as people, we are diverse in thought. And so the extent to which we might feel like our solution is the solution, it probably leaves out many other possibilities.
Think how much smarter it would be for kids whose parents are economically vulnerable, have to go to work, if they were in a safe place and could get that. Why don't kids, every private school in this state, from 7th and 8th grade on, you have to have an activity, not fall, not winter, not spring, all. Think how much public school kids need that.
Because the issue of racism needs to be dealt with in America now. And the issues in our local communities need to be addressed now. I'm talking to all of us. including myself. If we don't, I don't think that we're going to be a nation. We certainly are not going to be as strong as we are and as strong as we have been.
That's right.
It's just a fact.
That's right.
Martin Luther King had it. He said we're going to either live together or we're all going to die together.
So in Delaware, we continue to be patient. We continue to work to try to get through the barriers and create a conversation with our citizens so that we can move forward on our reforms. I don't have any of the answers. I know we continuously think and rethink about how we can engage our community in this discussion. We are planning more public hearings and on community engagement and on having the conversation this summer to coincide with our work on implicit bias. We're working with the News Journal to do that. And we're going to keep trying, like all the rest of you, to try to find some answers to make our system better and more fair for all. So if you have any questions, I'm happy to address them, but that's some of our challenges and some of our successes too.
Good afternoon. I'm the only thing that stands between you and dinner, so I'll try to keep it brief. My name is Nina Hess-Sue. I'm the General Counsel for the Supreme Court of Texas, and our Chief Justice, much like the other Chief Justices you've seen on the videos today and heard about, was very interested in having a conversation about the courts and trust in the courts, specifically as it relates to the criminal justice system and minority communities. And he wanted to do something a little bit different than the Tavis Smiley listening tour. He wanted to Texify it in a way. And so we decided that the format we would choose in Texas was a one-day summit, an all-day summit called Beyond the Bench, Law, Justice, and Communities. We held it in December of 2016 in Dallas, Texas. Chose Dallas as the venue for our first such summit, mostly because the city had suffered a terrible event a few months earlier in July of 2016. There was a fairly brutal police shooting in downtown Dallas, and 5 officers were killed and many more injured. And so we thought that was a community that really needed to have that conversation at that particular time. So we started working on this event 3 months before the date, which in retrospect was a very ambitious timeline, and we really wish we had had a few more months to pull it all together. But we did. We set our goal and we accomplished it, and we held it in December at Paul Quinn College, which is a historically black college in South Dallas. It worked out to be a very good venue for us. Capacity at that venue is about 200 to 250 people. So we did do an invitation only scenario, but we tried very hard to include, lots of different constituencies in that. It was convened by both of our highest courts. Texas is a different kind of a state in that we have 2 high courts, the Supreme Court, which handles civil cases, and the Court of Criminal Appeals, which is our highest criminal appellate court. And so both courts, our 18 justices, all agreed that this was a priority for them and that they wanted to put time and effort into arranging this summit. The purpose of it was to enhance public trust in the courts and to listen and to encourage attendees to hear each other out. And as I said before, it was invitation only. We did have security concerns. And so that was a major part of our planning process, was planning the security. A lot of advanced coordination, worked with the local law enforcement in Dallas. They were very generous to give us a number of officers to help us out with our event and make sure that everyone coming in had an invitation and was on the list, et cetera. So we really may have gone above and beyond on security, but when you're dealing with judges, public officials, and high-ranking people, you can never really be too safe. So that's something that we learned from that. And our invitees, we tried to include a lot of different sectors. There were, of course, a lot of judges from every level of the judiciary in Texas. The bar, law enforcement, community activists, clergy, educators, college students, and politicians were all kind of people that we included on the guest list. This is kind of a brief breakdown of what our agenda for the day looked like. It went from 10 a.m. to 5 p.m., so we had about 7 hours, and we had lunch in the middle. And we had our keynote address was by a police chief, Art Acevedo, who was the police chief of Austin when we started planning the summit, but by the time it happened, he was the police chief of Houston, the biggest city in Texas. He gave a very moving keynote, and you'll hear a little bit of it in my video. We had a testimonial panel, which had a number of different types of people. We had an exoneree, an African-American man who was an exoneree for a crime that he didn't commit. A student whose brother was killed by law enforcement, a police officer, a widow of a fallen Dallas police officer, and a pastor. So that was kind of a heart-wrenching part of the day, but very important to include that, I think. Then we had an academic presentation on unconscious bias by Professor Riklinski. That was kind of a good for all of those analytical types, the judges and the lawyers in the room who really like to have the data and that sort of piece of it. We did then a role-playing panel, which we had people deconstructing their decision-making process involving like a juvenile who had committed a crime in school and whether they would charge him as a minor or an adult, and all of the different various viewpoints of the prosecutors, the defense attorneys, the school officials, the law enforcement, et cetera. That was a really interactive panel and went very well. Then we kind of split everyone into breakout sessions and let everyone talk and come up with some ideas or solutions. Instead of just kind of talking at them, that was our time to all speak to one another and what have we learned here today and how do we take this back to whatever our job is or our community is. That was only 45 minutes long, the developing a plan of action piece, and as we got into those discussions, people had a lot of things to say, and we really wish we had allowed more time, I think, for the breakout. Or maybe multiple breakouts throughout the day might have been better than saving everything for the end. And then we had closing remarks from a pastor, Dr. Tony Evans, to kind of synthesize and talk about where do we go from here, what do we do with this information. So that was how we planned our event. And I believe my next slide is going to be a video with just some brief highlights of some of our speakers and portions.
The Supreme Court and the Court of Criminal Appeals have never, so far as I know, convened a meeting like this. It's just not what we do. We work in courtrooms. We study the law. We decide cases. But today, we and other judges who have joined us from all over Texas and across the country have left behind courtrooms and chambers, robes and gavels, and ventured beyond the bench.
As we prepare for the day, I want to be clear that the troubles and the challenges we face in today's society can be difficult to talk about, as I said. One day, coming together for one day is certainly not enough time to restore complete trust in our justice system. But as Paul Coelho once wrote, when we least expect it, life sets us a challenge to test our courage and our willingness to change. At such a moment, there is no point in pretending that nothing has happened or in saying that we are not yet ready. The challenge will not wait. Life does not look back. By confronting these problems and opening a dialogue, we take together, each of us in this room, an important step forward.
I just want to encourage us to let down our guards, to be in a place where you can acknowledge and understand that the only way we become everything that we're supposed to be is by listening, is by understanding that none of us have the right answer. But if we work together, all of us can get to a better place. And we are in a time in this country where we need people to be able to listen, to understand, to be able to walk in the shoes of someone else without judging them from your perspective. We have to work together. If not, we will be lost. And we have come too far to be lost now.
I believe that a lot of times when you look at people of color, the reason they run, the reason they fight, the reason they resist the authority of the police officer is because they see the criminal justice system as not being fair, as not being impartial, as not giving them the same exact rules and consequences as similarly situated persons that are not persons of color. I believe that in my heart of hearts.
2 nights ago, we were at my house, my kids, my wife, and I pulled up, and there was a police car out front. And we live in a somewhat upper income neighborhood, cul-de-sac, not typically having a police there. And the police car was just parked there, and my kids run out there, and they said, they're looking out the window, why is the police here? Why is the police here? Who did wrong? Who did wrong? And I try to remind my kids, because I think sometimes, especially in people of color, when we see the police, we automatically jump to something's wrong. That someone's up to no good, something's happened, and we've got to be on guard. And I said, on some level, they're there to provide some security. I don't know why the police officers are parked in front of our house, but sometimes they just routinely stop, and then they move on. But my kids were just, and I think some of it is the bias that we have to our law enforcement that we've got to deal with, and some of the issues that have occurred, and so it fulfills that bias. But my kids were convinced there was trouble, and if the police are present, there's trouble, versus they are there to provide safety and security, and we've got to begin to change some of those challenges and those biases within our community.
So as I sat in prison, I realized that my trial was not right. I realized that there was a lot of evidence, exculpatory evidence, that was in the possession of the hands of the authorities in which we are supposed to uphold and reverence. They had this evidence, but they didn't present it. And so that rendered us handicapped against the system.
When we talk about justice for all, when we talk about a more perfect union, when we talk about these ideas and these concepts, we have to understand that, they're beyond, I guess, our reality and our experiences and the things that we see.
I've spent a lot of time with a lot of judges. They're very hardworking people. They mean well, and they have a deep commitment to egalitarian norms. There are always exceptions, of course. When you look through published opinions and you look through records, you can find a few judges that do give you pause, but it's a few. The vast bulk of them don't want to produce a system like this and don't want this to happen, and I expect much the same is true of the other actors in the system that produce this outcome. So the puzzle is that. How do well-meaning, well-intentioned people who don't believe that they should be producing a biased system like this and don't believe they are, nevertheless produce a system like that? And I think understanding that requires taking a bit of a step back and understanding just how our brains actually function and how they work a little bit.
Okay. So just to wrap it up, because I want a couple of minutes for questions, I wanted to give you a few lessons learned from our experience and direct you that we created a toolkit that kind of summarized everything that went into planning and selecting speakers and putting an event like this together. And that toolkit is available on the National Center's websites and your materials for this conference. If you have any interest in doing something like this in your city, state, town, country, then that toolkit is available to you, and you should definitely take advantage of it. And there are a lot of other resources on the Texas Supreme Court's website that talks about lessons learned and executive summary of the event and all kinds of things like that. So those are available on the txcourts.gov website under training materials and beyond the bench. And then we can open it for questions.
So I just want to open it up. At this point, there's a microphone running around. We want to use this one? Okay. So what kind of questions do people have?
Yes.
So clearly, police forces are doing the same type of work as courts are, probably a few steps ahead in terms of exploring strategies to engage the community. Sorry, I don't want feedback. They're developing apps, they're going out on the streets, they're trying to get on-the-ground community voices into their own decision-making. Do you think it's worth collaborating, or is that just opening the can of worms wider and police should be separate from courts in terms of setting their strategies or doing that type of community engagement?
So I just turned on my microphone because that's exactly what we're doing. So part of our Fairness Committee includes law enforcement officials. And when I was talking about the survey, the policing survey that's being done, the Fairness Committee is working in conjunction with the Council of Police Chiefs to issue that survey. We're working with their listservs to push that out to their communities. So we see them as a vital piece of this reform. And on the reforms that I was talking to you about, the pretrial and the code reform, we held focus groups with the police groups, both the union and the council of chiefs. So that's an ongoing conversation. And in fact, the retired police chief of Newcastle County is now my deputy. So that's how serious we're taking the partnership with law enforcement.
I just wanted to add that just quickly wanted to add that so many of the conversations that came up in that courting justice were hard to have if you didn't involve the police. And so being able to have both of them there at the same time would also have a benefit as well.
I just have a short question, and I commend you for all the efforts and the work that you're doing, and I commend you and keep it up. But one of the speakers just brought something to my mind, and that is the tide of disenfranchised individuals continue to come to our court every day. And so while we continue to talk about them, we talk around them, we talk through them, we always have to remember they have faces and we should talk to them.
Thank you. We have time for one quick comment or question, and then we need to close up.
Yeah, I understand that there was a lot of discussion, and it seems like a lot of the dialogue is around race. But is there any study, or are you guys working on any LGBTQ issues, and especially transgendered, and the juvenile justice system especially?
I spoke to you about the reforms that are directed at race because that's our Fairness Committee, but yeah, that's absolutely an ongoing discussion, and I know our court administrator from our family court who's in tune to juvenile issues is here, and I think that's a concern. So there's a lot of stuff that we have yet to do. That's just sort of the first thing that we're addressing, but it's absolutely a concern that we need to be focused on.
At this time, I'm sorry, we'll have to wrap up the session. I would like to acknowledge SJI and all of their work in funding this important initiative. Thank you for attending the session, and let's thank our panel, please.